Guess went bowling, huh?
Yeah, that was the holiday party.
Before we go on the record, did you work out framing the issue?
Yes, sir.
We did.
Terrific. Okay.
You want me to try to read it into the record?
Yeah, I'll let one of you read it into the record
Okay.
when I get to that point of my opening. Ms. Simpson also reminded me that the witnesses need to show their driver's licenses to her when they're called up. So if you could remind your witnesses that way they're not coming here without their driver's license and don't gotta take time out so they don't get it. Any other housekeeping before we go on the record?
We would like to invoke the rule of sequestration. And notice one of the witnesses is here in the room.
Okay. Well, we'll get to that point. Let me do the opening, and then if there is a witness in the room, he or she will need to leave under the once the rules involved. Okay. Silent cell phones. If you haven't done so already, please. That way we won't have any interruptions. Okay. And what I have, gentlemen, is I have my opening remarks. So let me go over what I have. And then once I'm done, if there's any other housekeeping, we can put it on the record. We're not on the record yet, but I'm getting ready to go on the record. If you're ready. Mr. Wilson, you ready?
Yes, sir.
Mr. DeRoder?
Yes, sir.
Okay. Madam Reporter, let's go ahead and go on the record. Good morning, everyone. My name is John Finnegan. I'm a local employment and labor law attorney and the arbitrator that's been jointly selected and appointed for this arbitration proceeding. It's my privilege to serve as the arbitrator for this arbitration proceeding and hearing, and I thank everyone who had a role in selecting me. This arbitration proceeding is being conducted under the Federal Mediation and Conciliation Services, otherwise referred to as FMCS Rules and Procedures for Employment Cases in the matter of arbitration between the union in this arbitration proceeding, which is the International Union of Police Associations, AFL-CIO, commonly referred to as IUPA, or the union. The grievant in this proceeding is Leslie, and I'll spell that L-E-S-L-E-Y, last name Goins, G-O-I-N-S. The union and Mr. Goins are represented in this arbitration proceeding by their attorney, Gary Wilson, from the law firm of Wilson & McCoy. The respondent employer in this case is the city of DeLand, which is represented in this arbitration proceeding by Alex DeRozier from the law firm of Fisher & Phillips. We're getting started with this arbitration proceeding at around 9:30 a.m. and we're in the City Council meeting room in the City Hall of the City of DeLand, Florida, where the attorneys for the parties have jointly agreed to hold this arbitration hearing. What I'd like to do at this time, even though I've announced who the parties are, and before I finish my opening remarks, I'd like to have everyone who's present in this hearing room today introduce themselves so where it's on the record. And Mr. Wilson, I'll start at your table. If you want to introduce yourself and the people around you, or let them introduce themselves, however you want to do that. Mr. DeRozier, I'll do the same. And then in the gallery, if you'd introduce yourselves. Starting with you, Mr. Wilson.
Thank you. I'm Gary Wilson on behalf of Wilson McCoy PA, representing the grievant and the union, IUPA. To my left is former officer Leslie Goins, G-O-I-N-S. And to my right is IUPA business agent Greg Crook.
Okay, thank you. Good morning, gentlemen. Mr. DeRozier.
Sure. Good morning. Alex DeRozier on behalf of the city of DeLand, from the law firm of Fisher & Phillips. And immediately to my left is Chief Jason Umberger, who is the chief of police for the city.
Okay. We have a videographer for the union who's making a video of and an audio recording of this. Sir, would you state your name?
I'm not with the union. I'm with an organization called VolutiaExposed.com, and I prefer not to state my name.
Okay. And lady in the gallery.
Cassie Goins.
Okay.
Eli Whittick, West Volusia Beacon.
Okay.
Lieutenant Long, Land Police Department.
Ms. Simpson, are you able to help us out?
If you didn't spell his name.
Could you spell your name, sir?
First name is Juan, J-U-A-N. Last name is M-I-L-L-A-N.
Okay.
HR Director for City and Land.
Carrie Lasky, HR Administrator, City of Deland.
Mr. Wilson raised that someone here was going to be a witness in this hearing. You're okay to stay during the opening, but if there's any witnesses who are going to testify during the hearing, once I finish my opening and the lawyers finish their opening, and I ask you to step out because of the rule, sequestration is being invoked, which simply means you can't be in the hearing room while the hearing is taking place and other witnesses are testifying. Thank you everyone for your introductions. I'd also like to introduce our court reporter who's immediately in front of me. Her name is Shauna Simpson. Ms. Simpson is taking down everything I'm saying and that you're saying. She's making an official record of this hearing. Ms. Simpson is going to assist me by keeping track of the parties' exhibits that are entered into evidence during the hearing. Ms. Simpson will also be administering the oaths of each of the witnesses that will be testifying during the hearing. As I said before we went on the record, if the witnesses could have their driver's licenses ready to show Ms. Simpson when they appear, we won't have to wait till the witness has that to show Ms. Simpson. Even though this hearing is being videotaped pursuant to the agreement of the parties and their attorneys, the court reporter's transcript of this hearing is the official transcript and not the videotape. Let me just go over a few housekeeping items and procedures for this hearing and how it's going to be conducted. This hearing is scheduled for 2 days, today and tomorrow. We were trying to start today at 9 o'clock, but always on day one, there's always housekeeping items, so we're starting a little late today officially. Tomorrow, I'd like to be ready to go right at 9 o'clock, so we finish this hearing in 2 days. We'll finish each day's hearing at around 5 o'clock. If we're in the midst of a witness, I'll go a little over, but I don't want to go too far over, so we'll find a good ending point. During each day of the hearing, we'll find a good time to take a mid-morning and mid-afternoon break and a lunch break. Please come back from the breaks during the hearing timely so that we can stay on track with finishing this hearing in 2 days. While we're on break, if I cross paths with you in the hallway, the restrooms, if I only acknowledge you briefly and don't engage in small talk with you, it's not that I'm trying to be aloof or unfriendly. Instead, I want to remain impartial and avoid any appearance of favoritism, so I'll not engage with small talk with anybody during this hearing. The plan for this hearing, so that both parties have essentially an equal amount of time to present their respective cases, is that the city will go first and present its case, which I expect might take up most of today. And then tomorrow, since it's a 2-day hearing, is for the grievant and the union to present their case. This probably goes without saying, but as the arbitrator, it's my job to conduct an organized, civil, and professional hearing. As the arbitrator, it's my ultimate responsibility to conduct a fair and impartial hearing for both sides. I will endeavor to be fair and equal and consistent as much as possible for both sides as I run this hearing. I will not be an advocate for either party, nor can I suggest any legal advice or recommendations on how the attorneys for the party should present their cases. I know both Mr. Wilson and Mr. DeRozier to be experienced and competent labor law attorneys, so I'm sure they'll do a fine job presenting their side's cases without my involvement or interference. I have been appointed to only decide the grievance that has been brought before me, and I cannot decide any other grievance, claims, or issues. The parties, by and through their attorneys, granted me this authority to serve in this capacity as the arbitrator by agreeing to arbitrate this matter under the FMCS rules and procedures. And again, I appreciate the opportunity to serve as your jointly selected arbitrator for this hearing. In conducting this hearing, it is my desire to hear all evidence that may be relevant, reliable, necessary, and of value to me in deciding the grievance in this case. The FMCS's rules allow me to conduct this hearing as I deem appropriate and to also ask any questions of the witnesses. My style, however, as an arbitrator is to let the attorneys for the parties do their job, present their cases without a lot of questions from me. The attorneys for the parties may examine their witnesses with direct and cross, and one redirect and recross. I don't want to to multiple redirects and recrosses with no exceptions on that. If I have any questions of the witnesses, it will be generally after the attorneys have finished their direct and cross and redirect and recross, and then if I have questions, I'll ask them. And I'll allow each of you some redirect or recross if I have any questions. If I have any questions, please do not read anything into the fact that I'm asking the question. Doesn't mean I'm favoring one side or another, it's just something that I'd like to hear the answer to. Sometimes in arbitration proceedings, we are asked to take a witness out of order. I control the process for the hearing if either party needs to do that. Otherwise, again, I'll let you gentlemen present your witnesses in the order that you deem appropriate. In terms of the evidence in this case will only be decided on the evidence that is admitted into evidence during the hearing. In other words, today and tomorrow are the days to present all the evidence in the case. And when the case is over, the hearing is over, I'll ask the stipulation from both Mr. Wilson and Mr. DeRozier that they've had an opportunity to present all their evidence in this case, and they understand that the hearing is going to be closed with no additional evidence submitted after today or tomorrow when the hearing ends. As I said earlier, the city will go first and present its evidence for the just cause basis for Mr. Goins' termination. After the city presents its case, Mr. Goins and the union will present their evidence as to the grievance and why it believes the city did not have just cause to discipline and to terminate Mr. Goins. Evidence takes the form of both oral testimony and evidence. I ask the attorneys for the parties to exchange all their exhibits and their respective exhibit and witness list before the hearing, and I trust that has been done. What I've been given this morning are 2 notebooks of exhibits for the hearing, which is how I ask the attorneys for the parties to give me these. I have a white notebook that has grievance exhibits in the notebook, and I see from the exhibit list that there's a total of 42 exhibits in this white notebook. Since these are not joint exhibits, whatever exhibits in this notebook are going to get moved into evidence and can be moved in through a particular witness. I also have a black notebook of exhibits, which again is how I ask that these be given to me. This is the city's notebook of exhibits, and I see from the exhibit list that there's 16 in this notebook of exhibits. I have not seen or reviewed any of these exhibits. I won't look at them until they come before me when they're moved into evidence or offered into evidence during whatever case in chief they come in. This morning I was provided with a document subtitled Employee and Unions Proposed Stipulations. But because this was only from the grievant union side and not from the city side, I don't know what the attorneys have worked out in terms of these proposed stipulations, so I'll let the attorneys go on the record when we get to that point. In terms of the evidence in this case, I'll lean toward the inclusion rather than exclusion of evidence presented to me in this case, since the formal rules of evidence do not generally apply in arbitration. The attorneys for the parties may object to certain testimony and evidence. If there are objections, please direct them to me rather than back and forth to each other, and I will rule on objections right away unless I take an objection under advisement. After all the witnesses have testified and all the evidence is presented, I will then close this arbitration hearing. When I close the hearing, I will give each of the attorneys an opportunity to present closing arguments. The attorneys for the parties have already discussed and agreed during a pre-hearing conference with me that they wish to give opening statements today. We talked about their opening statements not being longer than 30 minutes. Once the hearing is closed, the attorneys for the parties will be submitting post-hearing briefs. At least that was the stipulation pre-hearing, unless that's changed. Their briefs will follow Ms. Simpson's transcript of this hearing within 30 days. So once we have Ms. Simpson's transcript, then the attorneys will be on the clock to submit their briefs within 30 days. After I get the attorney's briefs, I will issue my written decision in this matter called an award. The award will be in the form of findings of fact and conclusions of law, and I will issue my award within 30 days after I get the attorney's briefs. Once my decision and award is issued, my authority in this arbitration proceeding ends. As we got started, I handed out to Ms. Simpson and the attorneys for the parties what I call Arbitrators Exhibits, and this is what I received from the attorneys beforehand. Arbitrators Exhibit number 1 is the grievance in this case. The grievance is dated August 1, 2019. Step 1 of the grievance is dated August 1, 2019. Step 2 of the grievance is dated August 8, 2019. Step 3 of the grievance is dated August 15, 2019. I see a received on date in Human Resources of August 16, 2019. So that's admitted into evidence as Arbitrators Exhibit 1. Arbitrators Exhibit 2 is the union's demand for arbitration for Mr. Goins' grievance. And this is dated August 20, 2019. Arbitrators Exhibit 3 is the collective bargaining agreement that was applicable during the time of the grievance and Mr. Goins' termination. And this is for fiscal year 2018 and 2019. Arbitrators Exhibit 4 is an order setting forth the plans and preparations for this labor arbitration hearing that I issued to the attorneys for the parties on Friday, December 10, 2021, based on the pre-hearing conference that we had on November 4, 2021. I'll ask the attorneys for the parties, starting with Mr. Wilson, is there anything we need to change or correct in my order that I just referenced? Mr. Rogers, I'll ask you the same thing after Mr. Wilson looks it over.
Nothing, Mr. Arbitrator.
No change from the city as well.
Okay. So I understand from the attorneys for the parties that you have worked out the framing of the issue. One of you was going to read it into the record. So whoever's taking that task, please go ahead and do so at this point.
Thank you. And do you prefer being called Mr. Arbitrator or Mr. Finnegan?
Either or, whichever you're comfortable with. Don't call me Judge. Arbitrator Finnegan, Mr. Finnegan, whatever you prefer.
After some time to sit and discuss this with Mr. Rogers, we've agreed to make the arbitrable issue, it's 2 sentences, and I'll read them in. 1, whether Articles 8.1, 8.3, and or 8.7 were violated by the city.
Whether Articles 8.1, 8.3,
and or 8.7 were violated by the city. And if so, what is the appropriate remedy? And by the way, I did handwrite this, and I left the place not the cleanest, but at least we'll have a written record that we can just sign off to the live.
Okay.
And then within that, as a second sentence, within the above determination, whether just cause applies under Articles 8.1 and 8.7.
Mr. DeRosiers, did Mr. Wilson read into the record the way you understand the issue's been framed?
Yes, Mr. Arbitrator.
Okay. So we'll enter what Mr. Wilson just read from his handwritten note. That'll be Joint Exhibit 1 by the attorneys for the parties.
I'll sign it, send it over. Would you like me to read the 2 brief 1-sentence stipulations as well?
Yes, if you have stipulations, then go ahead.
Yes, it's our understanding, without going into specific details, but one of the witnesses that we anticipated to call was the city manager, Mr. Boyce. He's dealing with a family situation and is unavailable. And he was the might expect, the final decision maker in this case. But we've agreed to work around this situation so he could be where he needs to be. So we agreed on a stipulation that reads, city manager Boyce received the recommendation of termination and made the decision to terminate Mr. Goins. In so doing, he relied upon the final IA report. Okay. And then the second sentence is the one that we agreed to before we had a caucus meeting, that the city has a progressive discipline policy that applies to law enforcement employees as well.
Okay. And Mr. DeRosiers, do you concur with those stipulations?
Yes, I do.
Okay.
I'll go ahead and sign it, if I can send that over to Mr. Rozier.
Okay. Just go ahead and give that to Ms. Simpson, and she'll mark this going to one, and then during a break, we'll get copies.
Okay.
So we're going to- I'm almost finished with my opening remarks. We've already talked about the rule of sequestration. The rule has been invoked, and I'd ask the attorneys for the parties to help me honor and enforce the rule as to their witnesses during this case. Are there any other housekeeping items that either side wants to raise and resolve before we move to opening statements? Mr. Wilson?
Nothing,
Mr. DeRosiers?
I have one. Is that camera the camera that the union is using to record the proceedings?
Yes, sir.
I don't want to sound sarcastic, but is there a reason that it's only pointed directly at me?
The only place available
Okay.
to get it.
Okay. It feels a little awkward, like it's kind of staring just at me.
It's back of my head.
Yeah. Okay, I'm fine with it.
My spot was taken.
That's right. That's where you were last time, right? That's right.
And while we're on the issue of the video being taken, the stipulation on that is that a copy of that will be provided to the city as a condition of allowing this proceeding to be videotaped.
That's fine.
Okay, thank you. Okay, other than that, housekeeping item by Mr. DeRosiers, anything else? Okay, Mr. DeRosiers, since this is a discharge case and the city is presenting its case first, I'll let you go first in terms of opening statements. You got the floor.
Thank you, Mr. Arbitrator. Mr. Arbitrator, this matter is about the decisions that we make as human beings once we realize that we've made a mistake. It's really about that crossroads and that moment between choosing to do what's right and choosing to do what's self-serving. Leslie Goins chose door number 2. On January 20th of 2019, Mr. Goins made a mistake. He conducted an unlawful search of an individual named Mr. Joseph Staff, S-T-A-P-F. A call had come into the DeLand Police Department about an individual, Mr. Staff, causing a disturbance at a bar, which is just a few blocks from where we are right now in downtown DeLand. The report was that Mr. Staff may be causing an altercation at the bar, and also that he might have a knife on his person. Now, former officer Austin LaFleur was the first officer to arrive on the scene, and he appropriately detained that subject in handcuffs for his safety and for the safety of everybody else around him. Shortly thereafter, Mr. Goins arrived on the scene. He steps out of his patrol car and he starts walking towards former officer LaFleur and Mr. Staff. And at the same time, Mr. Staff and Mr. LaFleur are walking towards Mr. Goins. At that time, Mr. LaFleur tells Mr. Staff within earshot of Mr. Goins, Mr. Staff is just being detained right now. Now, Mr. Goins then reiterates that same concept to Mr. Staff just seconds later, and he says, I'm just going to secure you right now. And then about 40 to 45 seconds later, he reiterates that again to Mr. Staff, and Mr. Goins says, right now you're just secured. You're not under arrest. Now here comes the mistake. Right after he tells this man that he's not under arrest and that he's just being secured, Mr. Goins starts digging in the man's pockets. He pulls out his wallet, his personal belongings, and then he ultimately finds 2 baggies of cocaine on Mr. Staff. Now, at this time, this man, Mr. Staff, was only detained, as both Officers LaFleur and Mr. Goins had told him several times, actually 4 times by that point. Now, when Mr. Goins ultimately finds the cocaine on Mr. Staff, what he says exactly is, quote, "Well, now you're going to be under arrest." Until that time, Mr. Arbitrator, no one had told Mr. Staff that he was under arrest. He indeed had been told 4 separate times that he was not under arrest. No one had told Mr. Goins that Mr. Staff was under arrest, and you will not hear today Mr. Goins dispute that fact. Now, later on, Mr. LaFleur, via his radio to dispatch, radios out the infractions that were committed by Mr. Staff in the form of code numbers or case numbers that officers use to represent the infractions that were committed. The 2 that Mr. LaFleur calls out are 27A, which is a civil trespass, and then one for the narcotics that were found on Mr. Staff. Nothing else, Mr. Arbitrator. Now, the issue, obviously, is that civil trespass is not a criminal infraction, so at that point, there is no justification for the search of Mr. Staff. And now we get to that crossroads. Leslie Goins, at this point, should have owned his mistake. Now, conducting an unlawful search, an unconstitutional search, is not a small matter. I don't think anybody's here to argue that today. But for rookie officers like Mr. Goins was at that time, they're really terminated for those types of mistakes, especially when they're inadvertent and especially when they're admitted to. But that's not what happened here. Instead, Mr. Goins and Mr. LaFleur decided to try and justify the search of Mr. Staff by retroactively tacking on a charge of resisting an officer without violence. So if there was an arrest, then the search could be justified. Now, Mr. Goins alleges that he saw from his patrol vehicle on a dark, rainy night, while his windshield wipers were going, and from several hundred feet away, an at most 3 or 4 second interaction between Staff and LaFleur that he believed constituted resisting without violence. And he testified during the internal affairs investigation that by the time he got to the scene and got out of his patrol vehicle, he was operating under the assumption that Mr. Staff was already under arrest. Now, Mr. Arbitrator, other than Mr. Goins' testimony and the internal affairs testimony from Mr. LaFleur as well, all of the evidence that's going to be presented here today, and particularly the BWC videos of both Mr. LaFleur and Mr. Goins, will expressly contradict his defense. Now, again, nobody told Mr. Goins that Staff was under arrest. Nobody told Staff that he was under arrest. Between Mr. Goins and Mr. LaFleur, they told Staff 4 times that he was not under arrest. When Mr. LaFleur was investigating the disturbance and talking to the bar employees, he specifically told those bar employees, "We're just going to let him go, but we'll make sure that he doesn't come back here. We'll issue the trespass." Again, when Mr. LaFleur called out the dispatch 2 different case numbers for the infractions that were committed by Mr. Staff there on the scene, he only called out 2, a civil trespass and one for narcotics. At the scene, there was no mention of a charge of resisting without violence. And all of this is bolstered by the fact that at the time the state's attorney's office received the criminal charges against Mr. Staff, they dismissed those charges, all of them outright, because they concluded that there was no lawful basis to conduct a search of Mr. Staff. Now, an internal affairs investigation fleshed all of this out. It was conducted by Lieutenant Juan Milan, who you'll hear from today. And eventually, both Mr. Goins and Mr. LaFleur were terminated for those infractions, including lying and falsifying police reports. And I want to talk a little bit about that internal affairs investigation. Now, the union is expected to argue that Chief Jason Elmberger and his command staff somehow tainted this investigation. It's an allegation that's been used before against Chief Elmberger, and the essence of the allegation is that he used his position to somehow direct and guide the investigation to what the union refers to as a predetermined outcome. Now, first, the evidence is going to show that that allegation is false. The chief of police generally is the individual that orders internal affairs investigations. This matter was no different. Internal affairs investigations aren't final or complete until the chief of police signs off on them. He has to review the investigation report and the evidence gathered, and then it's ultimately his responsibility to make a recommendation as to proposed discipline, if any. So to the extent that he feels that any information is missing, certain statements or defenses need to be followed up on, it's entirely his prerogative to ask the investigator to do just that. And that's what happened here, Mr. Arbitrator. It actually was the deputy chief and the chief of police who asked Lieutenant Milan if he had attempted to corroborate Mr. Goins' defense of being able to see some alleged act of resisting an officer without violence. At that point, Lieutenant Milan had not done that. So in response, he followed up. He went back to the scene where the bar was, and he tested out Goins' defense in theory to see if it was credible. He determined that it wasn't. And then once he determined that it wasn't credible, the rest of the investigation falls into place. And the reason for that is, Mr. Arbitrator, if Mr. Goins didn't see or couldn't see some alleged act of resisting, the rest of his story has to be a lie. His entire premise, his entire allegation is operated under the assumption that by the time he arrived to the scene, Mr. Staff was under arrest. If that allegation in itself can be disproven or is found not credible, the rest of his story has to be a lie. But in any event, the union is expected to argue that Chief Umberger's involvement in this investigation was improper and even unethical. In fact, the union in this matter filed a complaint against Chief Umberger with the Florida Ethics Commission, making those very same allegations. And not in broad strokes, not generally that he does this as a matter of course, but that he did it specifically with respect to Mr. Goins and Mr. LaFleur. And the allegation was that he steered the evidence in this case to a predetermined outcome. Again, it was in a formal filing. It wasn't some minimal or cursory filing. It had a detailed summary of the allegations of improper conduct against Chief Umberger, and they attached several exhibits the union believed supported its claim. The Ethics Commission, however, determined that those allegations and the supporting exhibits were so legally insufficient that they must be summarily dismissed and not even merit an investigation. Also, what you won't hear today, Mr. Arbitrator, is any credible motive or incentive for this allegation that Chief Umberger wanted to steer the investigation towards a predetermined outcome of termination of employment. At the time that this investigation was ordered, Chief Umberger was less than 2 years on the job as the chief of police for the city of Delaney. He had personally hired both Goins and LaFleur. The allegations against Goins and LaFleur involved dishonesty to the point of falsifying sworn police reports. Anybody with a television or access to the internet right now knows how fraught and controversial that policing in America is. So allegations like fraud and dishonesty are, of course, likely to hit the news cycle, and indeed they did here, from the Orlando Sentinel to West 2 News to the Daytona Beach News Journal and several others. That's bad publicity, which paints the City of DeLand Police Department in a negative light, paints Chief Umberger in a negative light with the city, not to mention in a negative light with his boss, the city manager, as again, he was personally involved in hiring Goins and LaFleur. Chief Umberger's duty and his obligation here was to find the truth, but his incentive was certainly to corroborate Goins and LaFleur's story and clear them of intentional wrongdoing and save the city and himself the bad press. That's just not what happened. So the attack here in the investigation, Mr. Arbitrator, really is a red herring. I would ask that you focus today on how much of the union's defense is going to be focused on the investigation instead of the ultimate merits of this case. And here we actually have the benefit of that allegation of a tainted investigation having already been litigated in front of the Florida Ethics Commission. They brought their case, they filed their complaint, and the commission summarily dismissed that complaint for being without merit. So why are we actually here, Mr. Arbitrator? Mr. Goins made a mistake that's fairly common to rookie officers. He could have owned his mistake, and if he had, he'd likely still be working for the DeLand Police Department today. But instead, he chose to dig in his heels and try to justify an otherwise unlawful search, and the evidence that we're going to present here today will prove that. And so for those reasons, the city asks that the arbitrator deny the grievance in its entirety. Thank you.
Thank you, Mr. Rogers.
Mr. Finnegan, Mr. Arbitrator Finnegan, and those here, thank you for your time. This is a very serious matter that we're here about. A man's career and livelihood is now in your hands, Mr. Finnegan. So I appreciate at the outset your attention to what I'm about to say. If everything was just that you heard from Mr. Desrosiers, who I have great respect for, we've had now a few matters together, and I know he's representing his client, the city, and even though the chief, we had a prior case in this very room last year, had to cross-examine him, I'm going to have to do that again today in this matter. I know he's doing his job in a tough environment. I've represented police, law enforcement for 30 years now, various unions through Central Florida. And part of my duties is called upon to look at internal affairs reports and see if there was fairness in the process. Let me say what this case is not about, because if it was as just what you heard from Mr. Desrosiers, we wouldn't be here. I can assure you that the union only takes to arbitration the most serious of issues. And this is one such matter. This man right here and his beloved wife right here had their lives literally uprooted and torn apart because of that man, the chief. Now, he will tell you, and you heard a stipulation that the city manager was the final decision maker, and he's dealing with some family responsibilities that he needs to take care of today. But the stipulation that you heard is that he relied upon the IA report. An IA report that is replete with being tainted and steered by this chief. And it ain't the first time it's happened. I've been in this room twice, this being the second time, and you're going to hear now, this is the second time he's done this sort of thing. And he thinks he can do it. He thinks it comes with him being the chief. And I'm going to suggest to you, not only suggest to you, I'm going to show you where it's unlawful. And you just heard Mr. Desrosiers say something that is actually not true. I'll give him the benefit of the doubt that he misspoke. He said that an ethics complaint was heard. No, it wasn't. An ethics complaint was submitted. There was no hearing, no evidentiary hearing. They just summarily rejected it. Now, we can speculate as to the politics as to why, but one thing we know, that there was no hearing like we're going to have here today and tomorrow. There was no hearing over the ethics issues. And shame on that agency for punting it. But what you're going to hear over the next 2 days is going to be part and parcel to what that ethics commission should have done to roll up their sleeves and done their job. Because it flows directly into this case. It goes directly to the issues that are at arbitration here today under Articles 8.1, 8.3, and 8.7. This is a matter, let me say what this case is not about. And thankfully it's not. Because you're going to watch video here, Mr. Finnegan, shortly. I'm sure they're going to put on the video what's called BWC, body-worn camera, of this officer. But let me say what this case is not about. It does not involve excessive force or any report of an unlawful arrest or a threatened potential civil suit against the city. There was an arrest made, but here's the interesting thing. The man's attorney, unlike the other case we had, didn't even write a letter threatening the city. Made no claims, no monetary claims, didn't even make a claim in the letters that you will see in the evidence in this matter, didn't even make a claim, Mr. Finnegan, that the arrest was unlawful. All he did was send a preservation of evidence letter. That's all he did. Didn't threaten the city. He didn't say Officer Goins and Officer LaFleur violated his client's rights. He just wanted evidence preserved. It went on to the state attorney's office, and they issued a no information and dismiss the case, the charges against the person. And that's where the city is banking its case on. They're going to tell you, as you just heard in opening, that Officer Goins, and you heard him use the word red herring, and I know it's a legal term that we attorneys use. One red herring that I don't want you also to follow, just as Mr. Desrosiers said, is if you hear the name of Officer LaFleur, it's just too bad that he was a probationary officer. He didn't get his day. So anything you hear about Officer LaFleur and what he said, he didn't get an opportunity. The only reason Officer Goins is here is because he made it past 1 year, which entitled him to the grievance process and the arbitration rights that we're here about today. Officer LaFleur didn't make it to 1 year, so he got summarily bounced out. And his fight may be for another day against the city. But what we're here about is Officer Goins, because this is the process that he is afforded as a member of the union and making it past 1 year. So, a moment ago I said what this case is not about. There's no allegation of excessive force, no threat to the city, no monetary demand from his attorney, from Mr. Staff. What this is a matter involving an arrest for disorderly conduct disturbing the peace situation just outside the Boulevard Bar early on the morning of January 20th, 2019. All of this involves around, Mr. Finnegan, is a dispute over a pat-down or a search and the Monday morning quarterbacking by the chief as to what he thinks or what he assumes Officer Goins could not have seen. And you know what? He even put that in writing in an email that will be in evidence in this case. He writes, remember Mr. Desrosiers said he didn't tamper with the investigation, he didn't get involved. He writes an email while the IA is still open and suggests to the Internal Affairs investigator that Mr. Goins, Officer Goins, could not have seen what he saw. He puts himself immediately in the case and says, he couldn't have seen that. He must be lying. And that's not a chief injecting himself in the case, he's steering the case. I've done this 31 years now, in my 31st year. Absolutely got involved. In fact, I haven't seen anything like that in 31 years. All over Central Florida. I know he came from Pennsylvania. Maybe that's the way they do things up in Pennsylvania. And it's all copacetic. I know one thing, they didn't have an Officer Bill of Rights up there. And he's not crazy about having to deal with that down here. But it's the law. The very thing he's wearing the uniform for with 4 nice stars on his collar, saying that he upholds the law. He didn't do that in this case. He trampled on it. He trampled on this man's rights right here. Right here. Trampled on it. Ruined his career. You know why he ruined it? Because one of 2 things can kill a law enforcement officer's career. Excessive force and lying. Untruthfulness. He made that charge. He's the one that recommended termination. He's got to own it. And what he's going to have to own here before you, under God and all these witnesses, and under oath, under penalty of perjury, is he allowed a violation of the Officer Bill of Rights, which is a law. Last I checked, it's a law. And I bet you'll get up here and hear him say, because he's going to come across great. I've already seen him do it once, in a case they lost, on similar issues. He's going to get up there and sound all good and polished, like you would expect a police chief to do. He's probably going to tell you, like he said under oath last year, oh, I don't tamper with investigations. You know the problem with this one? We've got the evidence. He can't sit up there and deny it this time. We got it in his own words. His own public emails under Chapter 119 Florida statutes. That's another law. Florida has one of the most broad, open public records laws. There's no smoking gun here. We've got it. And you're going to see it. I'm frankly stunned that the city has made no effort, none, to resolve this. at a time when this department's down police officers, because I sat across the negotiation table and helped to bring about a new contract so he could have officers on this street. They're going to toss a good man away because he thinks he couldn't see what he said he saw? Are you freaking kidding me? And then call that a lie? Shameful. Now, mind you, the chief was not there late that night. Or early morning, it happened about 1 a.m. Nor was there ever a reenactment with the same conditions ever done. You know when they did a reenactment? And from what I heard in our joint conference, we're all going to get on a little bus and go down there and see it. Hear it. 10, 11, 12, noon. We're going to see this nearly 3 years after the incident. This happened on January 20th of 2019. January 20th of 2019. We're nearly 3 years removed from it. We're going to get on a bus like a jury. We're going to go up around the corner and stand up proud the Boulevard Bar and try to hear Lieutenant Juan Milan explain with a straight face a reenactment he did in June of 19, 6 months after the fact. Not the same conditions, and it darn sure won't be the same conditions today. But apparently, the city's going to put that in their case in chief and try to get you to believe in broad daylight with cars and traffic and trees growing for nearly the past 3 years that Officer Goins couldn't have seen what he saw on January 20th of 2019 at 1 in the morning. And you ask yourself, does that pass the smell test? Is that even the remote fairness and due process? Officer Goins was an 11-year experienced law enforcement officer. He had 10 plus years before he came to DeLand. He was abruptly terminated by this chief. Now, he will tell you he didn't terminate him, he only makes a recommendation, but I've been down and worked with this city and opposite enough. This city manager is a rubber stamp, for the most part. He's not going to cross his chief. Heck, the chief works for him. And that was despite the city having a progressive discipline policy that's now been stipulated to. He had no discipline, and the city has a progressive discipline policy, and he got fired. He was a 9-month officer. He started here in March of 18, Mr. Finnegan, was terminated for an incident that happened as a rookie officer. Now, he had came 10 years as Department of Corrections. And why is that important? Because you're going to hear some terminology, and this came out in the IA, where Mr. Goins said a pat and a search, they were interchangeable words when he was at corrections. At worst, what you are going to conclude, we believe, when all the evidence is put in, Mr. Finnegan, is that there was a mistake in the use of the terminology. And what you didn't hear Mr. Desrosier say on opening, but you will hear one of the witnesses, Lieutenant Mathis, who said this looks to be like a training issue. You know what? The smartest guy in this whole process has been Lieutenant Mathis. Because he's the one that says, this looks like a training issue. I don't see, he even says that. I don't see any intent here to falsify a report. And then you have to get beyond the smoke for a moment and say, what motivation did he have? As a rookie officer, 9 months on the job between March 18 and January 20 of 2019, to lie. When you see on video about a drunk, stupor guy who's not cooperating, he's resisting a little, he's slurring his speech, and when Officer Goins gets there, the floor is already there. And this is the big part of the matter, Mr. Finnegan. as he's driving there, he gets there in a matter of 20, 30 seconds. He sees Mr. Staff pulling away. Well, that's resisting without violence. There's a statute on that. And that statute will be in evidence in this case. Resisting without violence. That's what he said he saw. So when he got there, he believed that his fellow rookie officer, who had even less time than 9 months on the job, Officer LaFleur, he believed that Mr. Staff was under arrest. He saw him pulling away. There was a basis to arrest. Now, they're going to try to get you to hang up on what what Officer LaFleur said, what Officer Goins heard, but I don't think you'll get them to acknowledge, or deny, I should say, that Staff may have fit two statutes. One was breach of the peace and disorderly conduct, and even resisting without violence. So, at that moment, that was the information he was operating under. He proceeds to do a pat-down. They're going to tell you it was a search, because in his back pocket, he found 2 little bags of cocaine. Now, the city's going to have you believe that Officer Goins literally risked his career, that he fought hard to get to, by lying on what he saw to justify an arrest. Now, one other exhibit that will be in evidence in this case is there's a policy, and it's called Prisoner Detainee Transport Policy. And interestingly, that very policy calls for, just want to read you one line out of the policy, calls for the arresting transporting officer. Now remember, the policy is titled not only for prisoners, it's prisoners